Hey guys, just me again. We're going to put a trigger warning at the top of this episode because it deals with a sensitive subject. If this isn't for you, no worries. Skip on ahead to another episode. Please take care while you're listening and protect your own mental health. We hope that you enjoy this bonus episode, and we'll talk to you soon. Enjoy. Hey, welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Today we're bringing you a special bonus episode, brought to you in collaboration with the folks over at the Legal Writers Collective. Go on and check them out on our website or at legalwriterscollective.com. Hope you enjoy. The Queen and RLS. Court of Appeal for Ontario, heard May 20th, 2020 by teleconference. On appeal from the sentence imposed on August 12, 2019 by Justice Richard T. Knott of the Ontario Court of Justice. Mr. S. appeals from a 9-month sentence imposed on August 12, 2019 for counseling a child to touch him for sexual purpose and for touching a child for a sexual purpose. He asks that this court reduce the sentence to less than 6 months so that the opportunity to appeal from a deportation order will not be lost. The appellant's moral blameworthiness was elevated. The victim was his daughter. When she was between the ages of 4 and 6 years, he had her watch pornography with him that depicted daughters performing sexual acts on their fathers. During this time, he had her touch his erect penis with her hand. On another occasion, he would sit with her and play an internet game depicting genitals. On yet another occasion, he sat her on his lap when his clothes were off and his penis was exposed. The accused pleaded guilty and was very remorseful. When the allegations came to light, he attempted suicide. He was a 51-year-old first offender who had otherwise led a pro-social life. He was a permanent resident originally from Tennessee. He himself had been sexually abused by other teenagers during his adolescence. At trial, the Crown sought a 12-month sentence. The defense suggested that 6 months less a day would be appropriate. The sentencing judge noted that the victim impact statement demonstrated that the effect on the victim was obvious and telling, that she would be dealing with the after effects of the appellant's actions long after he was released from custody. The sentencing judge noted the seriousness of the offense, the obvious breach of trust, the young age of the victim, the element of grooming, and the repetition of the sexual contact. The sentencing judge was aware of the immigration consequences of his decision, but he did not think that deportation to the United States amounted to the severe hardship that might result from deporting to other countries. He concluded that the immigration issue was of lesser consideration than others. The appellant's moral culpability was high. If anything, the sentence was lenient in light of the principles explained in The Queen and Friesen. While a sentencing judge may exercise his or her discretion to take collateral immigration consequences into account, the sentence ultimately imposed must be proportionate to the gravity of the offense and the degree of responsibility of the offender. Inappropriate and artificial sentences cannot be imposed in order to avoid collateral immigration consequences. See The Queen and Fam. The sentencing judge was aware that the appellant had lived in Canada for approximately 20 years, had supportive friends, and was gainfully employed. Despite the serious consequences of a deportation order, he concluded that a 9-month sentence was required. Here, the sentence of imprisonment is not demonstrably unfit, nor did the sentencing judge make an error in principle in arriving at the 9-month sentence. There is nothing which displaces the deference owed to the decision of the sentencing judge. In these circumstances, there is no basis for this court to intervene, and the appeal from the 9-month sentence of imprisonment is dismissed. The appellant also asks the court to set aside the order prohibiting him from, quote, attending a public park or public swimming area where persons under the age of 16 years are present or can reasonably be expected to be present, or a daycare center, school ground, playground, or community center, end quote. In particular, he submits that the definition of park is so broad that he is left unable to safely assess where he can and cannot go. The appellant's past conduct does not suggest that he constitutes a risk to persons present in parks, and this condition can be tailored to target the remaining risks more narrowly. Paragraph A of the prohibition order will be varied to read as follows. A. Attending a public swimming area or community center where persons under the age of 16 years are present or can reasonably be expected to be present, or a daycare center, school ground, or playground. The parties agree that paragraphs A, 1, and B will remain as in the prohibition order. The parties also agree that paragraphs C and D should be varied to more narrowly define the prohibited conduct. Those paragraphs of the prohibition order are deleted and the following prohibitions substituted. C. Using a computer system within the meaning of subsection 342.12 for the purpose of communicating with a person under age 14 years. D. 1. Not to access the internet or use any device capable of accessing the internet or any similar communication device while in the presence of a person under the age of 16. 2. Under any circumstances, not to use any telecommunication device to access the internet or other digital network in order to access or possess child pornography or pornography depicting acts that are illegal under the Code, possess or access any images of children who are depicted to be or appear to be under the age of 18 who are naked or are portrayed in a sexual manner, or access or participate in chat rooms, bulletin boards, or other social media that discuss or promote child exploitation, child pornography, sexualized images of children, or other exploitation material. 3. Not to use or permit to be installed on any device in your possession any program or service designed to allow anonymous use of the internet. Accordingly, the appeal is allowed only to the extent of varying the prohibition order imposed by the sentencing judge.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.